Oklahoma Court of Criminal Appeals upholds the requirement for specific intent to prove assault with a dangerous weapon. I'm Tulsa attorney James Worth, and that is the issue that we have today is a new decision from the Oklahoma Court of Criminal Appeals. It is the case of Eddie Havens versus State of Oklahoma, F 2022. 1085. And in that case, he is charged with a few different charges, but the important one here is assault with a dangerous weapon. And the facts are somewhat interesting. He was at a family event, it sounds like, and he showed, hey, look what I got. And he had purchased a pipe bomb. And then he went out into the yard, and then he ignited that, and then he ran into the house, and there were some kids out there, and he called them, like, hurry, run to the house. Getting everybody to run to the house, and the first kid made it in the house okay. The second kid was getting close to the house when the pipe bomb went off. And that kid looks like thrown by the blast a little bit, but ultimately there was no property damage and no injuries. Scary incident, dangerous incident, nobody hurt, but they charged him with assault with a dangerous weapon. He was ultimately convicted and went up on appeal to the Oklahoma Court of Criminal Appeals. So I want to talk about the elements. What is the state required to prove beyond a reasonable doubt in order to convict someone of assault with a dangerous weapon? Well, they have to prove an assault upon another person with a dangerous weapon without justifiable or excusable cause and with the intent to injure or do bodily harm. So that is the main one that we're talking about, the intent to injure or do bodily harm. So there are two types of cases, generally speaking, general intent crimes and specific intent crimes. And this one, that last element makes this a specific intent crime because it's not enough to intend the act, setting off the bomb. It is required that you have the intent to cause the harm, in this case, injury or bodily harm. So this went up, and the state was fighting this, suggesting that they should not have to prove specific intent. They wanted to make it more like they had to prove general intent, that anybody acting this way and lighting a pipe bomb when there are children around, that is reckless, and that it is easily foreseeable that people are going to get hurt, and it's a disregard for those risks. And although those things may all be true, that does not indicate that he intended the kids to be hurt. In fact, all of his actions indicated that he didn't. He set the bomb off away from the home and he lit it, and then he was telling them to run away from it into the house for protection. So all the evidence suggests that he didn't intend to harm them, but the state wanted to say, oh, we're not required to prove actual intent, this general intent, this negligence, this recklessness, that he should have known that it would have caused harm, and therefore he intended harm because he should have known it was going to, and he did it anyway. But, and we've seen a lot of cases like this in recent, couple decades, where more and more the state is getting away with not having to prove specific intent, and more where they just get to have to prove general intent, or the courts have just reduced those requirements, reduced the burden on the state to prove that. One example that we've seen regularly is cases of child abuse by injury, a charge of child abuse by injury. And there is a really horrific case from the Oklahoma Court of Criminal Appeals, just a horrific circumstances where essentially a child was beaten to death, and it was argued on appeal that they've got to show specific intent. And rather than just find specific intent in that case, because it was clear the damage that this person did to the child was just extreme, the court made a finding that general intent was enough. It was enough for the court to say that he intended the act, not the harm. So you just have to intend the act in that horrible case, hitting the child, not the harm, that the child would be injured and die from it. So in that case, the result is okay, but there should have been enough to find specific intent in that case, but instead they changed the law. And they did it not through the legislation, but through a court case. So now in the state of Oklahoma, if somebody's charged with child abuse by injury, rather than having to show intent to actually abuse or harm a child, they just have to show proof of the intent to commit the act. So for example, if you're playing catch with your son, you throw the ball at him and it hits him in the face because he missed it and didn't catch it, and that gives him a bloody nose. Well, we've got an injury to a child, and we've got an act that was intended, meaning throwing the ball. So that meets the requirement of general intent. So that would be enough to be bound over for prelim and go to trial before a jury. We're looking at potentially life imprisonment, because the court has changed the rules there that says that it's not specific intent, it's general intent. But here, I've got to get some props to the Oklahoma Court of Criminal Appeals. They did stand their ground here, requiring that the state prove specific intent and indicating that all of the evidence indicated there wasn't specific intent to do harm. So ultimately, the court vacated that conviction for the assault with dangerous weapon and found that he was not guilty of that crime. However, he was guilty of a couple of other offenses that aren't relevant here. So that is the decision that we have. The court did uphold the requirement of specific intent there, so that's a good decision from the Oklahoma Court of Criminal Appeals that provides protections for people before their rights are taken away and they're convicted, that the state actually has to prove that a crime was committed beyond a reasonable doubt. So if you're dealing with a circumstance like this in Oklahoma courts, you're going to want to talk to an attorney privately and confidentially, not just receive general information from a video. So to get that scheduled with an attorney at my office, you can go online to makelawEasy.com.